This is our final part of the tenant rights and fair housing training series that has been brought to us and collaborated and led by Bay Area Legal Aid. So part 1, 2 weeks ago, was on tenant rights. Last week, we had a training on fair housing, and our final part to conclude this series is an eviction overview. Before we get started, just want to introduce myself and my colleague. So my name is Nicole Thomas. I'm joined by my colleague, Monica Porter. We're both from home base. We're a technical assistance provider, and we work very closely with the county's Office of Supportive Housing. We help organize an array of annual trainings, with this training series being one of them. And today, as I mentioned, this training series has been led by Bay Area Legal Aid. And so we have Anna and Laura with us, and I'll let them introduce themselves.
Hi, I'm Anna Ratner. I'm a housing attorney at Bay Area Legal Aid, and I'm out of their San Jose office.
And hi, my name is Laura Bear, also an attorney with Bay Area Legal Aid in our Santa Clara County Regional Office.
Thank you both. So for just some quick tech for today, you'll note that we have muted everyone upon entry. That's simply just to minimize background noise. We definitely want interaction and engagement throughout. So please feel free, if you have comments or questions, to be popping them in the chat throughout. We will be actively monitoring the chat, so please feel free to do that. And then there'll also be opportunity for you to come off of mute and ask your questions if that's easier for you. And we also want to note that closed captioning, it has been made available. So if you're not able to access the subtitles, please feel free to send either myself or Monica a direct message. We would be happy to walk you through that or any other tech issues you may be having. And finally, just want to note and reiterate that all of the training materials, that means the slide decks and the recordings for this part, but also the last two on tenant rights and fair housing, they're all going to be made available to you. All of these materials are going to be posted on the COC website on the training page. And we will send out an email notifying you all when those materials are available. So I did send the slide deck out by email yesterday, but if you didn't receive that, rest assured you all will receive the recording and the slide decks very shortly. So without further ado, I just want to have a quick icebreaker to make sure everyone's familiarized with the chat, and seeing as we are very close to Halloween, it's going to be Halloween themed. So for today, I want to know either what your favorite Halloween costume you've ever either worn yourself or seen someone else wear has been. Okay, and as you pop it in the chat, I will hand it over to Anna and Laura. Thank you.
Great, thanks, Nicole. So today's agenda is ambitious. So bear with us. We're going to start with just an overview of Bay Area Legal Aid services, and then we're going to dive right into COVID-19 tenant protections, state and federal, and the emergency rental assistance program. And then we're going to sorry, there's no, okay. And then we're going to do an overview of the eviction process, from the notice that starts off the eviction process all the way to after judgment. Next slide, please. So Bay Area Legal Aid is a legal services organization that provides free legal services to eligible low-income residents in the Bay Area. We cover all 7 counties: Alameda, Contra Costa, Marin, Napa, SF, San Mateo, and Santa Clara. And as you know, Laura and I work out of the Santa Clara County office. The practices that our office has are housing preservation and homelessness prevention, which assists clients in addressing landlord-tenant matters, defending against illegal evictions, asserting tenants' rights under fair housing laws, and combating discriminatory housing practices. We also assist clients with subsidized housing issues by helping them with preserving their Section 8 vouchers or tax credit units. The immigration practice provides services to immigrant survivors of domestic violence. These services include VAWA self-petitions, U-Visa petitions, temporary restraining orders, and other services for survivors in conjunction with our domestic violence prevention practice. The Health Consumer Center assists clients with navigating services from public and private health insurance programs, such as Medi-Cal, Medicare, in-home supportive services, and other county health programs. Our DV and sexual assault prevention.
Anna, I think you might have.
So I promise.
Oh my God, I've been muted that whole time.
Crisis hotline, and it should be noted that there are.
Who is talking?
I think they've been muted. Go ahead.
Okay, I've been muted for, for a long time while I was talking. So I'm just going to say that really quickly. I'm just going to name our practice areas. Housing preservation and homelessness prevention, immigration services for survivors of domestic violence and sexual assault, Health Consumer Center, domestic violence and sexual assault prevention, economic justice, consumer law, and the Youth Justice Project. I am so sorry for my technical failure. Next slide.
So we can only assist eligible clients to become a Bay Legal client. Someone needs to live in one of the 7 counties that we serve. They also need to either be a citizen or an eligible immigrant. So U.S. citizens, those with permanent residency or applying for permanent residency, as well as refugees, asylees, and any immigrant who is a survivor of domestic violence, sexual assault, human trafficking, or other violent crime. We can also represent eligible children in public benefits or domestic violence matters, even if their parents may not be eligible. And in general, we can only assist those that are at or below 200% of the federal poverty line, except for our health work. So anyone who's seeking assistance from our Health Consumer Center, there is no income requirement. Next slide, please. And here's just how to access our services. So there's our legal advice line. The numbers on the slide, they're open Monday through Thursday from 9:30 to 1 p.m. We have been having a lot of callers. The best advice we can give is to call early in the morning. If someone's not able to reach an attorney on the phone that day, they will give a call back. The number will come from a blocked number most likely, and that's to protect our clients who are survivors of domestic violence. And then the Health Consumer Center number is on the slide as well, and they are open Monday through Friday from 9 a.m. to 5 p.m. Next slide, please.
Thank you. All right, tenant protections related to COVID-19, and particularly as they apply to the eviction process. Next slide, please.
So here's just a quick snapshot of some of the different protections at various levels of government. Early on in the pandemic, we have the CARES Act, which is still applicable. There's also state laws like AB 3088 and extensions of those like SB 91 and AB 832, as well as state rental assistance, which is a huge protection for tenants who are at risk of being evicted for non-payment of rent due to COVID-19 related rental debt. Next slide, please. So we do want to make clear about the CDC moratorium. That's no longer in effect. Unfortunately, it did provide some protections for tenants who couldn't seek protection under the state law. On August 26th, the Supreme Court essentially ruled, vacated the stay and basically said that the CDC exceeded its authority in creating this moratorium. So tenants will no longer get any benefit from signing or filing that CDC declaration. Next slide, please. And briefly, just to cover the CARES Act. So the CARES Act was signed into law on March 27, 2020, and it established an eviction moratorium for 120 days. And it prevented certain landlords from filing eviction actions based on non-payment of rent during that moratorium. It also stated that covered tenants couldn't be charged late fees for any unpaid rent during that 120-day period, but tenants are still responsible for that unpaid rent. So although the moratorium itself expired 120 days after it was passed, the CARES Act still requires landlords in covered properties to serve a 30-day notice. So essentially where a landlord could serve 15-day notice if it's during the time period, which we'll cover in the later slides, or a 3-day notice, which now is back in the eviction field. So instead of a 3-day or 15-day notice, landlords are required to serve a 30-day notice for non-payment of rent. So this is still in effect. And who is covered under the CARES Act? So it covers, a few weeks ago, we went over VAWA protections, which applies to federal housing. So any VAWA program is covered under the CARES Act. And it includes federal housing programs under HUD, also Department of Agriculture and Rural Housing voucher programs, as well as most popular in Santa Clara County, which is Section 8 vouchers, as well as project-based Section 8 and low-income housing tax credit units. And also, lastly, the CARES Act also provides property owners with foreclosure protection, where owners may request a forbearance for a period of time. And in multifamily properties with more than 5 units, an owner may not initiate an eviction or evict a tenant while the forbearance is in effect. Next slide, please. So now we'll go over California Tenant Relief Act, so the AB 38A and its extension SB 91. So there are different protections depending on which months of rent the landlord is requesting. So last year, AB 38A got passed, and it provided that rent due between March 1st of 2020 and August 31st of 2020, that cannot be a basis for eviction. So that period, as long as the tenant provides a signed declaration of COVID-19 related financial distress. For rent due between September 1st, 2020 and September 30th, 2021, a renter who completes that COVID-19 related financial distress declaration and pays 25% of the rent due for that period can never be evicted. If they can never be evicted for not paying that remainder 75%. But landlords can sue in small claims or in general civil court beginning November 1st for any unpaid rent. And also any notice that is served for that covered period of time, March 1st through September 30th, 2021, it needs to be a 15-day notice instead of a 3-day notice, and that does not include weekends or judicial holidays. It also must include a blank copy of the COVID-19 related financial distress form to give to tenants, so that tenant can sign and return that within 15 days if it's applicable. And it also needs to include required language from the state of California, note about tenants' rights and the rental assistance that can be available. And lastly, the notice does have to be in the same language that the lease was negotiated in. Also, the court has mass UD cases for rent due between March 1st, 2020 and September 30th, 2020, if COVID-19 related rental debt is sought in that case. Next slide, please. So here's just what the declaration of COVID-19 related financial distress looks like. A landlord who seeks the rental debt between March 1st, 2020 and September 30th, 2021 must serve a blank declaration along with any notice. The deadline to return this notice is 15 days after receiving it. If a tenant did not provide a landlord with a signed declaration of COVID-19 related financial distress, they can still have an opportunity to file one with the court after being served with the summons and complaint within 5 days. So we'll go over this later in the presentation, but a tenant has 5 days to respond to a summons and complaint. That does not include weekends or judicial holidays. And that same time period is when a tenant can also file this COVID-19 related financial distress declaration. After then, the court will schedule a hearing to determine whether or not the tenant's failure to return the signed declaration was a result of mistake, inadvertent surprise, or excusable neglect. And if the court does find that it was a result of mistake, inadvertence, surprise, or excusable neglect, then the court will dismiss the unlawful detainer action. So it's still applicable, even though it doesn't apply to rent post October 1st. Next slide, please. And next, we'll talk about EB 832. This is just a further protection. It doesn't have some of the protections from EB 3088 or SB 91, but it still has many important elements that can protect tenants, including how the unlawful detainer process is now supposed to be completed. So from October 1st, 2021 through March 30th, 2022, a landlord seeking rental debt cannot get a summons, which is what is needed to start the unlawful detainer process. So they can't get a summons from the court unless the landlord provides either a signed statement that they applied for rental assistance for that unit and provides a copy of the emergency rental assistance program's final denial. Or if they provide a signed statement that they completed the rental assistance application for that unit and 20 days have passed since either the latter of the application or since the landlord served the 3-day notice. And the landlord has not received any notice that the tenant submitted a completed application, and the landlord has not otherwise heard that the tenant applied for emergency rental assistance. Or if the landlord provides a signed statement that the tenant moved in on or after October 1st, 2021. So these protections don't apply for any tenancies that were established after October 1st, 2021. Next slide, please. So there may be stronger local protections around just cause. So for example, San Jose's tenant protection ordinance, and there's also state just cause requirements. Tenants should try to get help from a legal aid organization like Bay Area Legal Aid because the intersection of these laws can be complex and confusing and overwhelming. So we definitely encourage tenants to seek legal assistance. The new state laws do prohibit legislating tenants more time to pay COVID-19 related debt, and it can't start later than May 1st, 2022. And the new state law also gives landlords extra time to demand rent that was owed during earlier parts of the pandemic. So for example, generally there's 1 year, there's a 1 year limitation where to evict tenants for non-payment of rent. If there was a local law in place in response to the pandemic that protected tenants from evictions, that time period is what's called tolled. So there's extra time for landlords to bring a non-payment eviction, even if it's been more than 12 months. Next slide, please. And next, California State Rental Assistance. So this is very important for tenants to try and get emergency rental assistance if they have non-payment that was related to COVID-19. The state has promised to pay 100% of rental assistance for low-income renters below 80% of the area median income. And we've also had some callers be confused that they think September 30th was the last day to apply for rental assistance because that was the date that, was stated that protections are ending, but that's not true. Tenants can apply for emergency rental assistance after October 1st. And tenants can also seek assistance with paying their utility bills as well. Next slide, please. So a tenant can apply and receive for up to 18 months of rental assistance. And this can be for past due rent, and it can also be for prospective future rent, which is really great to help tenants remain stable. So a tenant who has moved out of the unit can still apply for emergency rental assistance for their previous unit, but that landlord will not get any future rent. And again, as mentioned in the last slide, a tenant can also receive assistance for utility bills. It is important for renters to apply for emergency rental assistance. It can provide an additional defense when faced with an unlawful detainer action. Next slide, please. And one last emergency rental assistance protection. So if a tenant has gone through the eviction process and there has been an eviction judgment, but the tenant has not been evicted yet, and the tenant receives emergency rental assistance, that tenant should immediately file what's called an application to prevent forfeiture due to COVID-19 related rental debt. There's a link on the slide to the form where that can be found on the court's California court website. It's really important to file that application as soon as possible. So if a landlord receives the full payment of the rent demanded in the complaint from the emergency rental assistance program or the tenant, then the court must grant the application and set aside any judgment that was issued and dismiss the case as if the case never happened. If a landlord has not received the full payment yet, then the court will set a follow-up hearing that's 15 days out that will not include weekends or judicial holidays, and essentially stay the action and not allow an eviction or what's called a right of possession to take place so that the tenant can remain in the unit while they're waiting for the landlord to receive the emergency rental assistance funds. At the follow-up hearing, so if the government rental assistance program has withdrawn the approval of rental assistance, then the court can't deny the application. But if the plaintiff has received all the payment, then the court will set aside the judgment, will grant the application, set aside the judgment, and dismiss the case, which is really great for tenants so that they can stay in their unit. If it's still unclear if the program hasn't withdrawn the application but payment hasn't been received, then there'll be another follow-up hearing to try to see if that landlord will get the emergency rental assistance program funds. Next slide, please. So here, tenants can file their applications at Housing is Key. They should call the rent relief call center, and the phone number is on this website, on the slide. They can also just go to the website if they need any assistance. But definitely, we've heard some experience with the call center and the call back, especially if someone is limited English proficient, but definitely try to call to get the status of the application. Next slide, please. Thank you. Now move to the eviction process. Hannah?
Was trying to keep up with the questions in the comments. One moment. Okay. All right. This is a real quick overview of what the eviction process looks like. It starts with written notice from the landlord. And then after the notice expires, the landlord files an unlawful detainer action, which is just the formal name for the type of lawsuit that accomplishes an eviction. The tenant then has the landlord serves the complaint for the lawsuit on the tenant, and then the tenant has 5 court days to respond to the complaint. After the tenant has filed their response, or after those 5 days have expired, the landlord asks the court to set a date for trial, which is usually at most 21 days from the date of the landlord's request. So it's a short turnaround on the trial date. Yeah, and then if the tenant loses at trial, the landlord gets permission from the court to have the sheriff perform a lockout, which is about a 5-day process. All right, next slide. It's super important to keep in mind that landlords are not allowed to evict tenants through any other means than going through the court process. Any other way of accomplishing an eviction is illegal. And these are called self-help evictions. If a landlord does evict a tenant through an illegal means, the tenant could theoretically sue the landlord for illegal eviction or unlawful eviction. Specific things that the law prohibits are landlords changing the locks on tenants or blocking the tenant from gaining reasonable access to their home with the intention of terminating the tenancy. The only way for a lockout to happen legally is for the landlord to go through the court process, get the court's permission to have the sheriff conduct the lockout. Additionally, landlords cannot shut off utilities with the intention of terminating the tenancy or making the place unlivable and forcing the tenant out. And if a landlord does engage in self-help eviction, they may be subject to civil and criminal penalties, including up to $100 per day that the tenant is locked out of the home. Next slide, please. This is another more detailed visualization of the eviction process. So again, in order to start the process, the landlord must serve you with a notice in writing, which has to be for a specific number of days, depending on the type of the reasons the landlord is providing for the eviction. The notice must be properly served on the tenant for it to be valid. If the notice is improperly served, the eviction lawsuit can be dismissed. When the notice expires, the landlord can then go to court to file the unlawful detainer action. After they file the action, they must serve the tenant with a summons and complaint, which are these initiating court documents. And again, these also have to be properly served. There's like a manner specified in the law to do it. Once a tenant is served with the summons and complaint, they have 5 court days to file a responsive pleading. This is usually filing an answer to the complaint. There are other ways to challenge the complaint, but we have only so much time today, so we are not going to get into it. The most important thing to keep in mind is once the summons and complaint is in the tenant's hand, to file an answer or some other allowable response within 5 court days. After the answer is filed, again, the landlord requests a trial date from the court, set within 21 days of the landlord's request. A tenant can then request a jury trial. There's a form for that. They would have to submit it in order to get their jury trial. It is usually helpful for tenants to request jury trial if they know to do it, because jury trials take more time and cost more money. And so that's leverage that you can get against your landlord. Generally, after the trial date is set, you obviously go to trial. Usually the judge decides the case on the same day. If the tenant wins, the tenant gets to stay, although they will also have to pay any rent owed. And if the landlord wins, the judge issues a writ of execution of judgment, which the landlord takes to the sheriff's office. The sheriff posts a 5-day notice to vacate. And then after the 5 days are up, the sheriff performs the lockout. In that little window between when a tenant loses at trial and before the sheriff actually changes the locks, a tenant can file a request for a stay of execution, which is like, lock me out, but lock me out a little bit later. From the court, which those are sometimes granted, but the tenant will have to pay for that rent, the rent owed for that, for those extra days that they get. Many cases get settled before trial. Also, in which case the parties would enter into a stipulated agreement. We'll talk about that a little bit more at the end if we have time. Next slide, please. All right, y'all. Have you personally ever helped a client complete an answer in response to an eviction filing? Do we have a, yeah. So it looks like just a few of you. Anyone else want to get in their answer? All right, yeah, just a few of you have. The rest of you, this may be a lot of new information all at once, but that's the point. We should have asked, I guess, have you ever had a client ask you to help complete an answer? Just to get a sense of that. Anyway, next slide. All right. Legal bases for an eviction. A landlord in California there are a lot of reasons that are allowed for landlords to evict tenants, but a landlord can't evict a tenant for just anything. The most common, or at least pre-pandemic, the most common would have been for non-payment of rent. Once rent is past due, a landlord has to issue a notice saying either pay or get out. And as Laura explained, from March 2020 through September 2021, tenants had the option of filing that COVID declaration of financial distress to kick in some protections from eviction. But going forward, for rent that came due after September 30th of this year, that 15-day notice isn't useful anymore. Another basis is violation of lease terms or rental agreement. If a landlord has violated a part of the lease, or if a tenant has, or if the landlord just believes that the tenant has violated a part of the lease, the landlord can give the tenant a notice saying to fix the problem or to leave the property. It's called cure or quit. At the end, a landlord can evict someone who either is not on a lease, in other words, a month-to-month tenancy, or who's at the end of their lease term, if no other protections apply. A month-to-month tenancy is considered to reach the end of its term every single month. And a landlord doesn't have to give a reason for terminating a month-to-month tenancy unless another protection applies. But they do have to give either 30 days or 60 days notice, depending on how long the tenant has lived there. And in rent-controlled cities, landlords cannot evict tenants once the rental period of the lease has ended without some additional cause for termination. Another basis for eviction is that the rental property is being foreclosed. in that case, landlords are required to give 90 days notice to the tenant. And finally, if the tenant is involved in illegal activity on the property, the landlord must give them a 3-day notice. Usually just a 3-day notice to quit, because without an option to cure, although doesn't necessarily have to be that way. There are also local ordinances that provide protections to tenants, such as the San Jose Tenant Protection Ordinance, and there are state laws like AB 1482 and AB 832, which Laura just discussed in some detail, that provide more protections. And then if the tenant remains on the property after the notice period expires, and the problem is not fixed, then the landlord can go to the next step of the eviction process. And this is, I guess, a little bit duplicative of, no, sorry, next slide. This is a little bit duplicative of what we already said, but it lays out the different notice periods and what sort of causes require different notice periods. So again, 3-day notice is again in place for non-payment of rent. 3-day notice is standard for a notice to cure. And a 3-day notice is also required in general for most tenancies. If, say, the tenant has done something irreparable on the property, like, I don't know, assaulted a neighbor or something. A 15-day notice is for non-payment of rent that came due between March 2020 and September 30th, 2021. And again, it must include that declaration of COVID-19 financial distress. A 30 or 60-day notice is for all month-to-month tenancies. And actually, if you're in a unit that is covered by the CARES Act also independently requires 30-day notices. And then finally, a 90-day notice is what's required for any property, any rental property that's being foreclosed on, and for any termination of tenancy for a tenant that has a Section 8 voucher. All right, next slide, please. Hypo. Tammy owes rent from March 2020 through August 2020. Her landlord serves her a 3-day notice to pay or quit, and Tammy is unable to pay. Can her landlord evict her based on this notice? Anyone else want to get an answer in? All right. So most of you got this right. It's definitely a tricky one. No, the landlord can't evict her based on this notice. I mean, unless the judge is really lazy. The landlord should not be able to evict her on this notice. Because from March 2020 through August 2020, landlords are required to issue a 15-day notice. So no matter what the other facts are, the 3-day notice will not suffice. Next slide. This is sort of 3 hypotheticals on 1 page. Tammy tenant has the Section 8 voucher, and she moved into a unit on July 1st, 2018. Her lease expired on June 30th, 2019, but the landlord continued to accept rent from her. On December 30th, 2019, Larry landlord issued a 30-day notice to vacate the unit. True or false? The landlord issued a valid notice to Tammy. Marcus, do you have a question? I see your hand up.
I sure do. Hey, thanks. I really appreciated your statement that there is no legal eviction if it doesn't go through the courts. I think that's the first time I've heard that. Sure it is. So thank you. That really is helpful. I was wondering if there are slick ways that landlords try to get around that. I mean, like you just gave an example. It's a 3-day pay rent or quit. And the person believes, my goodness, if I don't pay this in 3 days, I'm literally going to be kicked out. That tenant doesn't know, doesn't have any idea that that's not legal. But I'm wondering if landlords do other stuff like, I mean, I assume, okay, there's got to be a court order. Do they like, write stuff up and make it look like it came from the court, cross out John Smith's name and put, Sam Jones, and Sam Jones has no idea that it's, I'm just wondering what other kind of stuff they pull to, because I have heard 3-day pay rent or quit. And honestly, I don't think I was aware that those were all illegal.
No. So here's the thing, right? You can issue a 3-day to pay rent or quit, just to be clear. That is a thing a landlord can do. But if after the 3 days passes, the landlord does not get to just change the locks. After the 3 days passes, that's when the landlord files the lawsuit.
Right. No, and thank you. But I know many people that I know have gotten them. They literally think in 3 days, the locks are changing and I'm out of here. That's what
a lot of people think that, and a lot of people just, like they're basically deprived of their rights because there's very little tenant rights education out there.
Right.
That's why we do presentations like this. But unfortunately, it does happen. Like, I'm sure it happens a lot because I only talk to the people who make it to legal aid.
Right. Are there any other slick things that landlords are trying out there to trick people? I'm just curious about that.
Another thing that landlords can try to do is, anything was mentioned, shutting off utilities to try to force the tenant to leave, because if the utilities are not on, the refrigerator's not working, the water is shut off, there's no way to take a shower, and can force a tenant out that way. But like Anna mentioned earlier, that is also constitutes an illegal eviction. Sometimes we,
the question is just, do the tenants know that they have rights being violated?
Exactly.
Figure out how to enforce them.
Try to request a civil standby with law enforcement. That hasn't always been effective. Sometimes, the police are helpful in telling the landlord to turn the power back on or turn the water back on. Of course, there's tenants are afraid to contact the police sometimes, which is reasonable, and it's up to the tenant. But it's definitely unlawful, and sometimes we step in to try to send a demand letter or get on the phone as soon as possible to inform and educate landlords.
Okay. Anyway, thank you so much. That's really helpful.
I think other people have their hand up too.
Yeah.
Really quickly.
Rosalia?
Yeah, thank you so much, Rosalia from Catholic Charities. I just want to give also an example that there are some families that are telling me that neighbors that are very good friends with the property manager, they tend to give them a hard time because the manager is asking them to kind of make their life very miserable so they can leave the apartments, which is a little bit more difficult to prove than actually the manager doing something against the tenant. So that's a very difficult situation that I heard some community members telling me about.
Yeah, no, that is just a difficult situation. Unfortunately, we can't give advice on specific cases in this venue, but if you know the tenants being affected in that way, I please ask them to contact legal aid, Bay Area Legal Aid, or anyone else. And then, is there someone else with their hand up, Ms. Hill?
Yes. So just to piggyback off of what Rosalia said, I do currently have a client experiencing the similar situation that she's speaking of. The landlord has asked neighbors to falsely accuse the tenant of violating the lease with noise complaints, things of that nature, unit violations or anything like that. And so, yeah, the landlords are definitely finding that area to go to and evict the tenant off of.
That is very sad to hear.
Yes.
And again, I mean, I sincerely hope that they contact legal aid or are otherwise able to get an attorney to assist with that. 'Cause
Okay.
that's really discouraging. Laura, do you have anything to add?
I think one thing I'll add is that, the unlawful detainer process, there is the possibility to go to trial. That's what starts. There is a lawsuit. A lot of times parties do settle before it gets to trial, but at trial there is the opportunity to defend against an unlawful detainer action. The landlord has to bring witnesses and they have to testify under penalty of perjury, and they can't lie on the witness stand. And that may prevent some people from making false statements when they're actually on the stand and may not want to go through that whole process. But there is a process through the courts, and there are ways to defend against those types of evictions.
Thanks, Laura. All right, so just to circle back to the hypos that we posted, most of you got number one right. The landlord did not issue a valid notice. And then I didn't read out two, but it was on the slide, so a lot of you answered it, which is good. If the hypo is, if the landlord issued an invalid notice, what is the amount of notice that Tammy tenant should have received? And the answer to that is C, she should have received a 90-day notice because she is a Section 8 voucher holder. And then do we want to, is there a way to put number 3 up, or should I just read it out? All right,
Put it in the, okay, here we go.
Okay, yeah, suppose Tammy tenant does not have a Section 8 voucher, then how much notice should she have received? Oh, I'm not actually, oh, no, we did, okay. Anyone else want to toss in an answer? All right, I'm gonna stop the poll. Or can I? Yeah. There's a lot of different answers that people gave to this one. The correct answer is B, 60-day notice. She's a month-to-month tenant, but she's been there for more than a year. So since she was there for more than a year, she's entitled to 60 days. All right, next slide.
So now we will talk about the eviction process. And Ellen in the chat said it does cost landlords money to bring a lawful eviction case. It does. So landlords do have to pay filing fees when they're trying to start an eviction action, unless they qualify for a fee waiver, but that's generally unlikely. So next slide, please. We will talk about the different steps in the unlawful detainer case. So first, which is very important, calculating the date the answer or response is due. There's deadlines when it comes to lawsuits, and it's really important that tenants meet these deadlines to prevent any negative action occurring. Step 2 is to review the unlawful detainer summons and complaint. So see what the allegations the landlord is making and how to respond to them. Step 3 is reviewing the notice. Really important to see generally unlawful detainers are based on the notice that was served to the tenant. Step 4 is completing the answer. We'll go over completing the answer. There are other responses that a tenant can file to respond to an unlawful detainer action. The purpose of this training will review the answer, which is the most common response, and also to request a fee waiver if they're eligible, so they don't have to pay any filing fees when they file their pleadings. Step 5 is to find someone who's not a party to the lawsuit to mail the answer or serve the answer on the opposing party or their attorney, and to sign the proof of service, so that can be filed with the court. Step 6 is to file all the documents with the court, file the answer, the request for a fee waiver, and also the proof of service. And then the last step is to prepare for court. So we'll go through each of these. Next slide, please. So step 1, calculating the deadline to file the response or the answer. It's really important. So when someone is served with the court documents, it'll say, summons on it, it'll say complaint. They'll be stamped by the court. So that's something to look for. It'll have a case number as well. That is when basically a stack of documents, that's when someone knows that they're served with a unlawful detainer action. To calculate the date, you don't count the first day that the documents are received, but you count the last day, and you only count court days. So it's not weekends, no Saturdays, no Sundays, and no judicial holidays. On the slide, there's a link to a list of all the judicial holidays. I think Abraham Lincoln's birthday is a holiday. So there's some ones out there that may not be as widely celebrated and taking the day off. So definitely it's a good resource to look at what the court holidays are. And for example, if a tenant was handed a summons and complaint, personally, that's personal service, today, October 28th, then they need to count the days. So Friday is day 1 is when it starts. Monday is day 2, Tuesday is day 3, Wednesday, day 4, Thursday is the last day. So that's November 4th would be the last day to file a response in court. It's important to file the answer or response within the time period, because then they avoid losing by default, which Anna went over earlier. Even if the deadline is passed though, a tenant or defendant should immediately try to go to the courthouse, file something so that they avoid losing by default. They can still file a response if the landlord has not, or the plaintiff has not requested a default. So at that point, it's a kind of a race to a courthouse. There have been instances where a landlord, goes immediately that day that they can request a default. Some landlords or plaintiffs don't request it immediately. And so at that time, there is still an opportunity if the deadline is missed. And also unnamed persons, so persons that are not named as a defendant in the unlawful detainer, can file what's called a prejudgment claim to right of possession. So this would allow them to enter the case. We definitely caution those to file a prejudgment claim to right of possession, because if they insert themselves in the lawsuit, become a named defendant, and lose, then that judgment may be on their record and prevent them from renting to future landlords. Next question, please. Next slide. So here we have a poll question. Teresa, tenant, tells you that she received a summons and complaint on Sunday, October 31st. When is the last day that Teresa may file her answer to the complaint? Give it just a few more seconds. I'm gonna send it. All right, so majority answered Friday, November 5th, and that is correct. Again, don't count weekends, but here there wasn't any weekend because it was served on the 31st, which is a Sunday. And then so the last day to file would be Friday, November 5th. Great. Next slide, please. So this is the first page of our answer packet. We're currently working on updating our answer packet to reflect the newest court forms. And once we complete the update, we will send out our answer packet. It includes a very detailed guide on all the defenses and objections that a tenant can raise. It also includes an attachment that a tenant can use to just kind of check the box and fill in where necessary to add a brief description of their defenses or any objections that they have. So on the first page of our answer packet, there's a little handy tool equation that someone can just insert the day that they were served, count the 5 days, and that's the filing deadline. There's also a link that they can use to determine where they can insert the date that they were served, and it will tell you the deadline to file. Next page, please. Next slide. So step 2 is reviewing the unlawful detainer summons and complaint. Here is just a picture of the summons. It will have on the top right, this is a blank one, but on the top right, it will have the court stamp, the date that it was filed. You can look for the case number, the name and address of the court. So that's where all the tenants or defendants pleadings will be filed as well. And it has a plaintiff or plaintiff's attorney's contact information. So this is where a tenant or defendant will serve their documents on. And then also the complaint does now have a mandatory cover sheet. It's really important to read everything, all the allegations that are in the mandatory cover sheet and in the complaint, because that'll be helpful when drafting a response to the unlawful detainer complaint. And then it is long. There are, the font is not the biggest. It may take a while, but it's really important to read that thoroughly to kind of understand the plaintiff's position to create the best defense for the tenant or defendant. Next slide, please. So step 3 is reviewing the notice. So a copy of the notice must be included in the summons and complaint. It's usually labeled as an exhibit. It's really important to read the notice carefully so one can see what defenses are applicable. If the notice is defective, the whole unlawful detainer must be dismissed. The reason is because these eviction actions, as Anna went over, they're very short. They're not like regular civil actions where someone has 30 days to respond. Trial can usually be set out for a year. There's a lot of time for discovery between that. Here, eviction actions, unlawful detainers are called summary proceedings, and they happen very quickly. And the reason that everything needs to be a landlord or plaintiff must strictly comply with all notice requirements and other requirements of the unlawful detainer because it does happen in such a short period of time. So it's also important to list any defects that are in the answer. So for example, if it's the wrong time period, if there's no required notice language, for example, if they didn't serve, if they're requesting rent from the covered time period where a 15-day notice was required and it needed to include a blank declaration or needed to include that specific statutory language from the state, then that can always be inserted, that should be inserted in the answer as a defense to the unlawful detainer complaint. Next slide, please. Step 4 is completing the answer and also the fee waiver. So the first part, completing the answer. Again, make sure to have the summons and complaint in front to reference to when completing the answer. Our answer packet does have a helpful guide. It is quite lengthy, the whole packet, but we try to be very thorough to explain all the different defenses and objections that can be raised. And all named defendants must answer or else they risk getting a default. There is space on the answer for multiple defendants to sign one answer, so they don't have to sign or file separate answers. But it's important that if there are any competing or conflicting defenses, then it may be best to file separate answers. Also, it's important to make at least 3 copies of the answer. So 1 to file with the court, generally the original file with the court, 1 copy to serve to the plaintiff or the plaintiff's attorney, and then also 1 copy to keep for themselves to have a record of what defenses they asserted in their answer when they go to trial. Next slide, please. So here is just a picture of the answer with also it's annotated. So this is kind of what it looks like as a sample in our answer packet. It's good that the answer packet has expanded to include all these defenses where a defendant can just check the box that it applies to them. In this process, it has gotten very long and complicated and went from like 2.5 pages now to 5 pages. So it is a long document. The font is small, but it's really important to read everything carefully. On the very first page on the top there's the caption. That's where you enter in the name and contact information, as well as the party name, the case number, and the court where the action is being heard. And then also paragraph 2, this is really important. So if the whole complaint asks for less than $1,000, the defendant should just check the box that it's a general denial. So everything that was asserted in the plaintiff's mandatory cover sheet in the plaintiff's complaint has been generally denied. If the complaint asks for more than $1,000, the defendant, it's really important to go through and list each paragraph that they either believe is false or that they know is false, or they have no information or belief that it's true, and so they deny that as false. And that needs to be done for both the complaint and as well as the mandatory cover sheet. If the mandatory cover sheet was not served on the defendant, then there's a box that they can check on this first page that they never received it. So it is really important to list those denials, because if it's not denied, then the court will take it, as true. Next slide, please. So now on page 2 of the answer, there it starts to list out all the different defenses and objections that a tenant or defendant can raise. For example, there's non-payment defenses. If there are habitability issues, that can be a defense. Any, discrimination, housing discrimination, if there was a denial of reasonable accommodation, if there's any local ordinance that was violated, they should really read through all these objections and defenses carefully and check the box as to which one applies. If there is even an inkling or a thought that this applies to them, it's best to assert it, and it can be amended later. But if a person doesn't assert the defense or objection, if a person doesn't assert the defense, they risk not being able to bring it up later. There are some of these are objections. A landlord does have the burden of proof of showing that they provided a proper notice, but that can be raised as an objection as well, just to notify the court and bring it up front that they didn't comply and they didn't meet their burden of proof. Next slide, please. Again, this is just another list. We're not going to go through all of them here, but more defenses and objections that a defendant can raise. And then next slide, please. And so here, there's an opportunity for either the defendant to state and list out a brief description of the facts about each of the checkboxes that they've checked. We also, encourage those to put it on an attachment, and in our answer packet we have that attachment, which is just another way where people can just check the box and include a statement of the brief description of why that defense or objection applies. They can also make any other statements on the bottom in paragraph 4. So for example, if they have vacated the unit, it's really important to write that on the answer, because the unlawful detainer is based on possession of the unit. If a defendant or tenant does not have possession of the unit anymore, there's no need for this quick summary proceeding. And the judge will see if the tenant has vacated, and then it'll either get removed to the regular civil calendar, which is the longer period where people have more time to respond. The trial is scheduled out for longer. There's case management conferences, and generally landlords will not want to go through that entire process, and sometimes they just dismiss the case. There's also the opportunity to note if the fair market value is excessive due to any habitability repairs. If there's any habitability issues in the unit, we generally advise tenants to note that the fair market value that's listed in the complaint is excessive because of all the habitability issues in the unit. And then paragraph 5 is where they assert what they want. So if they want reasonable attorney's fees, if they want the plaintiff or landlord to make repairs, they can check those boxes. And then next slide, please. This is the last page. It's really important to sign in 2 places. So a defendant has to state whether or not they use an unlawful detainer assistant for compensation. So if they paid someone, generally, if they seek legal aid, they did not use an unlawful detainer assistant for compensation. So they need to acknowledge that portion. And then on the very bottom, there's the verification. And the verification is very important to sign because that's where they state that everything that's listed in the answer is true under penalty of perjury. And they have to sign that second portion as well. So it's really important to sign in 2 places instead of just 1. Next slide, please. So poll question, true or false? There's only 1 place on the answer where the defendant needs to sign. Just give it a few more seconds. All right, in the poll. All right, so majority said false. Yes, that's correct. There is not just 1 place where the defendant needs to sign the answer. There's those 2 places. It is, confusing why they need to sign in 2 places, but it's very important that they do. Next slide, please. So the complaint is demanding past due rent in the amount of $3,000. Can defendant check the box 2A, denying each statement? So just a general denial where they don't have to list every specific statement that is false or that they have no information or belief of that it's false. Give it a few more seconds. Okay, on the poll. So it looks like a majority said yes. Unfortunately, the answer is no. So the complaint, if it's requesting less than $1,000, then they can check that box and deny each statement. In this case, since it's asking for $3,000, then it's really important for that defendant to review each paragraph, each statement of the mandatory cover sheet and the complaint, and go through and list on their answer which one is false and which one they have no information or belief about, and so they're denying as false as well. Next slide. Here's just a picture of what the attachment looks like. There's, various check boxes. So for habitability defenses, they can check the box of what's not working. If they have other defenses, they can put in a brief description, but this correlates with all the defenses and objections that are in the answer and allows defendants to use this attachment to state what the brief description is. And we will be, again, updating the answer packet, and we'll share it with everyone when we have the latest version updated. Next slide. And again, here's just a picture that shows how a defendant can insert, the brief description of what the defense or objection is. Next slide, please.
All right. Step 4, part 2, completing the fee waiver. People with low income may be eligible for a fee waiver, which means if the court grants it, the tenant does not have to pay money in order to file paperwork with the court. This form is confidential and nobody but the court sees it and the tenant filing it. Questions to ask to find out if a tenant is probably eligible for a fee waiver. Ask if they're getting CalFresh, SSI, Medi-Cal. There's a list on the fee waiver form of benefits that sort of automatically mean you get a fee waiver. Even if a tenant doesn't get one of those specific benefits, the fee waiver also has a section for just like sort of summarizing to the court your financial situation and showing them that it would be a burden on you as a household to pay these court fees. If a tenant completes their answer and brings it to the court for filing but forgets the fee waiver, they can just ask the court clerk for a fee waiver for the fee waiver form and fill it out right there. Next slide, please. Step 5, find somebody to mail the answer and sign the proof of service. Someone who's not a party to the case must serve a copy of the answer to the landlord or their attorney, usually by mail. Service just means mailing a copy. This can be a case manager, for instance. Any person is eligible to serve the answer on the landlord as long as they are not a named party and they're over 18. And then after the person performs service, then they sign a form called a proof of service. And they give that back to the tenant so the tenant can file it with the court. Next slide, please. And this is a copy of the proof of service form with little like assist bubbles explaining what to put where on the form, although our assist bubbles are not in red, so it's a little harder to read than the answer pages. Next slide, please. All right, who can serve the answer on the plaintiff and fill out the proof of service of these options? The defendant's child that is under 18 years old, the defendant themselves, the defendant's child that is over 18 and a named defendant in the case, or D, anyone that is not named in the case and is over 18. Getting some answers in. All right, just a few more seconds. All right, I'm going to end the poll. Most people got the right answer. It is anybody that is not named in the case and is over 18. Next slide. Step 6, filing all those documents. It's no use if a tenant spends all that time filling out the answer and all these forms and never gets them to the court. You have to file the documents with the court, go to the clerk's office and hand them to the clerk. Or if the clerk's office is closed at Santa Clara County, you can drop them in the drop box. And you're going to want to file the answer itself, the fee waiver forms, and the proof of service. If the court later denies the request for fee waiver, then at that point, the tenant basically has to pay the filing fees. But if you at least submit a fee waiver, you don't have to pay up front. Next slide. Step 7, prepare for trial. Tenants will receive a notice of their trial date in the mail. This will come from the court, not from the landlord. So, you know, once you get served court paperwork, just keep an eye on. A tenant should always be looking at the mailbox. If for some reason you're worried that your mail's not coming through or it's been delayed for some reason lately, a tenant can always call the court clerk's office and ask if a trial date has been set in their case, or go in person to the clerk's office to ask. While you're waiting for a trial date to be set, the tenant should gather their evidence together. If there's any documents that they want to use at trial, they should make 3 copies of it if they possibly can, if they can afford it, you know, so that they can bring them to court and give 1 copy to the judge and 1 copy to the landlord, and then still have a copy to look at themselves. If the tenant has witnesses that they want to testify, that are willing to testify, make sure that they know what the trial date is, make sure that they're available to be there in court. And, you know, if the tenant is really organized, plan out what questions, they should plan out what questions they're going to want to ask their witnesses. Obviously, if you're going to trial, it is usually best to have a lawyer. So consider contacting Bay Legal Aid if you expect to be at trial, or you have a tenant that expects to be at trial, or any other legal aid organization. Also, just a heads up, tenants that need interpreters can ask the court to provide an interpreter. Next slide, please. All right, I forgot to incorporate this into our little 7 steps, but just super basics of how to negotiate a settlement if a tenant is approaching a trial date, or just even has had a notice issued. Either side can make a settlement offer. Common settlements include deals like cash for keys, where the landlord pays the tenant money to help them move, and the tenant gets out on a specific date in the near future and hands over the keys. If a tenant is considering a settlement, they can reach out to the landlord before the court date, or even in court on the day of trial. If the landlord drafts the settlement agreement, the tenant should read it carefully, and if at all possible, have legal aid or their own attorney review any agreement before they sign it. If the tenant is uncertain about an agreement that the landlord proposes, they do not have to sign it. In that case, you know, if the parties don't reach a settlement, the case just goes to trial. If a tenant does enter a settlement agreement and then breaches the terms of the agreement, usually settlement agreements say that in the event of breach of the agreement, then the landlord gets a default judgment, and the landlord doesn't have to go through the trial process all over again. So a tenant only wants to enter a settlement agreement that they're very confident that they will be able to comply with. Otherwise, they will still end up with an eviction, in all likelihood. All right, next slide. After trial, the judge makes a decision. If the judge finds for the tenant, typically that means the tenant pays whatever rent they owe and their tenancy just continues as though nothing ever happened. If the judge finds for the landlord, the judge will issue what's called a writ of execution, which I mentioned earlier in the presentation. The landlord takes this writ to the sheriff's office. The sheriff posts a notice on the tenant's door saying they have 5 days until the sheriff will change the locks. And then after 5 days, the sheriff can come and change the locks on the tenant and forcibly evict them if necessary. And again, in that little window between losing at trial and the locks being changed, a tenant can request a stay of execution from the court, but they have to have money up front to pay for whatever extra days they're asking for. Next slide. A couple of sort of basic tips and tricks for completing this paperwork. All of this paperwork that's involved in the UD process. Spell every name exactly as it appears on the summons and complaint, even if it is misspelled. A tenant should file their answer even if they think they've missed their 5-day deadline, because there's no harm to it. It might still, if the landlord is moving slowly, it might still work. And then what happens if the tenant doesn't know what happened at trial, or if doesn't even know if there was a trial or if it's been scheduled? The tenant should go to the clerk's office and ask for a copy of any documents in the file. And as a party to the action, the clerk should let them have that. All right, that's all. Any questions from anybody?
Hi, this is Ellen.
Hi.
This might be too specific, but I think I've heard that it has happened that individuals have gotten the notice from the sheriff's office posted on their door and not had any idea what's going on. I know you just stated that they can go to the courthouse and ask for documents. But would you be able to go over some like reasons how that could happen? I mean, I'm guessing the main reason is that they just didn't get their mail.
Sometimes what happens is, right, landlords or landlords' attorneys usually hire a professional server whose job it is just to go around, serving documents on people at different times and places. And sometimes those service processors, sometimes they get, the address wrong, there's room for human error. Sometimes I have occasionally heard of them just signing the proof of service form and never actually delivering it. I hope that doesn't happen often, but it seems possible. Laura, do you have any other thoughts?
Yeah, and if that's the case where someone has never been served and there is that, a default has been entered in the case that would allow a landlord to go to the sheriff to execute that writ of possession, then it's very important first for that defendant to get a stay. The stay can be granted up to 40 days post judgment. So the day judgment was entered, they have that 40-day window. Hopefully they're, given that sheriff's notice so they know. So they will request out the stay. They have to pay the amount, the daily rental value, to have the stay granted from the court. So it's basically a conditional order, and it's only granted if the tenant then goes back to the clerk's office and pays that daily rental value for the amount of stay that they requested, up to 40 days. And then what they can do is called a motion to set aside the default judgment because they haven't been served. And that's just another process where they try to get a hearing on a calendar in front of a judge, inform them, look, I've never been served. It's important for them to have any evidence of where they were, maybe, because what happens is that there will be a proof of service that states, it could be like so-and-so answered the door. They'll have a description of the person and like who they handed the papers to. And if they said like, no, I was at work this day and time, like I have my supervisor can vouch that I was at work and I wasn't home when they said that they, served, then, that's evidence to show that they weren't properly served. And they can go try to do that route to get the default set aside, and then it just starts back at square one, where they have the ability to file a response and an answer and go through that the actual unlawful detainer proceeding. So there is some remedy, but it is very important, if that does happen, that they act very diligently and quickly to try and get that overturned.
Makes sense. Thank you. That answers it.
I'm just going to also put in a request that everybody who's here, please, please, please fill out the survey. Nicole just put in the chat. That gives us information to provide to our funders so that they know that we're reaching people. All right. We still have some time for a couple